Greetings! This video is going to demonstrate how to incorporate exhibits into your mock trial presentation or competition. First, let us take a look at Exhibit A. Here's a brief description. This is just a description of the exhibit, and therefore this would not be used in a mock trial. This page is informative and just for you. In most cases, there won't be a description of the exhibit available, just the title, which will be found on the exhibit itself. Please note, it is only an exhibit until you ask the judge to move it into evidence. After that request to move it into evidence, then it is considered evidence and can be called evidence. The definition of an exhibit is a document or object presented, referred to, and identified in a court. The definition of evidence is data presented to a court or jury in proof of the facts and issue, including testimony, records, documents, and etc. In order to be admitted into evidence, it has to be relevant to a fact at issue, and it has to be authenticated or identified with someone who has personal knowledge of this data. This will lay a foundation for when we talk about how to move exhibits into evidence later. Since mock trial is timed, it's a good strategy to ask during a pre-trial to move any exhibits you plan to use during the trial into evidence. For example, if the case has exhibits A, B, C, D, and E, but you and your co-counselor are only going to use A, B, and D during the mock trial, then you would only ask the judge during pretrial to move those specific exhibits into evidence. If you do that during pretrial, you can refer to those exhibits as evidence. Additionally, you'll also save yourself time during the actual trial. If you do not ask during pretrial or at any point during the mock trial, then you cannot refer to the exhibits as evidence. Let's take a look at what this exhibit actually is. Let's scroll down. Here at top we have some background information, who it is to, who it is from, the date, the topic, and the coroner. These are great indicators of which witness could potentially authenticate the document which is required to move the exhibit into evidence. If there is a scenario where a document doesn't provide that information, then look for who created the document. The individual who created the document can always be used for authentication purposes. In a moment, we'll talk about what authentication is. In the main body of this particular exhibit, we have the message sent out to the fictitious school of Columbus University to the students from the dean's office regarding the university's hazing policy. We do need to incorporate this information into our examination of a witness. This video is going to how to use this information during both direct and cross-examination. Let's take a look at what to do for direct examination first. The first thing you need to do is ask for permission from the judge to present the exhibit. This must be done regardless of which side you're on. You would say something like, "Your Honor, permission to present Exhibit A to the witness." The judge in mock trial will ask opposing counsel for any objections. They should have none, and then the judge will grant you permission. Once the judge grants you permission, the next thing you need to do is show the exhibit to the opposing counsel. When you walk it over, you would say something along the lines of, "Your Honor, let the record show I am presenting a copy of Exhibit A to opposing counsel." Since mock trial is timed, it is recommended to keep a spare copy of the exhibit to give to opposing counsel. This way, the opposing team does not waste your time by looking at the exhibit. This is a strategy that many teams employ. When you give them the exhibit, you should say to the judge, again, "Your Honor, let the record show I am presenting a copy of Exhibit A to opposing counsel." And once more, if you have a spare copy, this will save you time during the competition. If you do not have a spare copy, then you'll have to wait as the opposing team takes their dear time to review the document as if they've never seen it before. This will waste your time, so please, if you can, get a spare copy of all exhibits you intend to use. The next step in presenting an exhibit is to establish the witness's familiarity with the document. This process is also known as authentication. You cannot do anything or ask any questions about what's on that document before you establish the relationship between the document and the witness. Additionally, the witness should describe what they see on the exhibit to the jury. Bear in mind, the only ones who know what is on that document is you, the opposing counsel, and the witness. No one else in this courtroom has seen this exhibit before. Again, this process is known as authentication. The purpose of this particular process is to have the witness explain A, how they're familiar with the document, B, that they have seen the document before, and C, that the document is reliable to the best of their knowledge. If you find that the witness is not specific enough, you can always add in more questions. It is important to listen to what the witness says to your questions. Remember, these questions are examples and are fluid. Have an idea of what you need to be said and make sure those points get across. You can always add in questions if you didn't originally have any intended. Note, if you have an expert witness on the stand, there are a few additional points to remember when the exhibit is being used as an expert report. First, you need to make sure you qualify your witness as an expert under the rules of mock trial, which will be reviewed in a different video. After the expert witness has authenticated the report, as previously mentioned, you will want the witness to give their ultimate opinion as it is stated in the report. It is imperative that you ask the expert if the opinion given in the report is based on, quote, a reasonable degree of whatever their expertise is, certainty. So, for instance, if it's a doctor, you would ask them if the report is based on a reasonable degree of medical certainty. This will ensure that the expert's opinion will be accepted into evidence as an expert opinion. If you do not qualify your witness as an expert, or if you do not get the expert to testify that their opinion is reasonable within a degree of certainty, the testimony of the witness will not be accepted as that of an expert. Remember, in the case of an expert witness, the expert is not only testifying that the report is accurate, but they are also testifying that the opinion within the report is accurate. Afterwards, you need to let the jury know what's in the document itself. They have not seen it whatsoever. They have no idea what's on it, except for whatever information you present through your line of questioning. So the jury needs to know what's there. Next, and lastly, at least for the last part of questioning, the most important part of your questioning is to pull the information from the witness that the jury should get out of the exhibit and how it relates directly back to the case. What do you want the jury to take from this exhibit? Why is it important? What does it prove? The witness is going to answer these questions for the jury, but it is essential as an attorney to ensure you're asking the right questions. Lastly, you ask for permission from the judge to retrieve the document before moving on to your next line of questioning. So essentially here we have three different parts of presenting an exhibit. The first one is identification, after, of course, the permission to present. So identification is right here in this, identification is going to be here. And then we have what is the document itself, i.e. is the document accurate representation of what is being reported, and lastly, why is this document important? This completes the direct examination questions. Let's take a look at some samples of cross-examination questions for the same piece of evidence here. So these are cross questions. Notice here that the difference is that we're looking at more leading questions. The information that's being presented is essentially the same, but again, the difference is the way the questions are phrased. Notice here we have, do you recognize this exhibit? Now, in this case, the name of the defendant is Mr. Archer. So we're asking him to recognize this exhibit. Whereas in the direct examination, we ask, have you seen this document before? This is a narrative question. And here again, we have the cross question or the leading question. In looking at this document, the document is about the hazing policy on campus, correct? Here we are forcing the witness to give us a yes or no answer. And then down here, once again, the most important part. So, according to what you just read, hazing is a violation of campus policy, as opposed to asking the question, can you please tell me, based on your understanding, what you just read as to the campus's policy regarding hazing? Again, these are direct questions, and here are a sample of cross questions. This is the end of the video tutorial on how to present exhibits during a mock trial presentation. Good luck!